In this video, I'm going to be talking about 7 things that you should avoid saying at your domestic violence restraining order hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to win your restraining order court hearing. So if that is something that you are interested in, you can get your free first class in the course via the link down below. Okay, so let's jump right in. 7 things to avoid saying, to avoid talking about at your restraining order hearing. Number 1, talking about being jealous. Now this is especially if you are the respondent, because the petitioner is trying to make you look like an abusive you-know-what. And so if you start talking about how the petitioner was always flirting with other guys or other girls, trying to make you jealous, trying to rile you, what the judge is probably thinking is, and then you got jealous, you got upset, and you became abusive. I mean, one of the reasons why murder can be reduced to manslaughter in some states is if you catch your spouse in bed with another person. It's well known that that is something that can induce rage and that can induce abuse. And that is something that if you're looking at the whole relationship and you're thinking, okay, but the other person was horrible. They were a horrible boyfriend, horrible girlfriend. I caught them cheating. They were awful to me the whole time. What you have to realize is it's not about who was a good boyfriend, who was a good girlfriend, husband, wife. It's not about that. That is not what a domestic violence restraining order hearing is about. It is about whether the judge believes, by preponderance of the evidence, meaning slightly more than 50%, that a restraining order needs to be issued to prevent future domestic violence. So, if the petitioner is a cheating jerk, that doesn't necessarily mean that there doesn't need to be a restraining order. Maybe you're still really angry about that. Probably you are. And one of the worst things that can come out is it can be very difficult to talk about these things without being angry. Even if you're over the person. If you start talking about these things, most people are going to be taken back to it and seem angry, unhappy, emotional, sad. Emotions that you really don't want coming out at your restraining order hearing because it's not going to help you. Number 2, details of arguments. Why the two of you had an argument on a certain day. It does not matter who was right and who was wrong in the argument. Now these 7 things I'm going over are a general rule. You can get a domestic violence restraining order without there actually being physical violence. So if they're saying that there was some sort of coercive control going on, like you controlled all of the finances, all of the family planning, everything that happens in the relationship, you were controlling it all in a sort of non-consensual way. This is a rare way to get a restraining order, but it can happen. Okay, in those cases, if they're saying that you were financially abusive or controlling, but actually they went out and bought a Chanel bag and you objected to that when you found out how much they cost, then that might be relevant, but you don't need to go into all of the nitty-gritty. Focus on what is relevant. And again, this is something that I teach you in the course, how to figure out what is relevant, how to figure out what is important. That's going to be really important to know before your hearing. Number 3, shaming the other party for promiscuity. First of all, it is not important. Second of all, it makes you look sometimes angry or jealous. Third of all, you have no idea what the judge has been up to in their personal life. Someone can be promiscuous and they can also be the victim of abuse. Someone can be a cheater and also the victim of abuse. You see where I'm going here with this? You're not litigating every aspect of the other person and their personality and their flaws. That is not what the hearing is about. And if you try to do that, then it can make you look abusive. So if you're representing yourself, I mean, you can represent yourself and win your restraining order hearing if you know what to do, but you have to realize what things to keep out. Number 4, talking about the other party liking rough intimacy, unless the injuries that they are alleging that you caused were actually from that and were totally consensual. People bring this up all the time in domestic violence criminal cases and in domestic violence restraining orders. And generally when I'm talking to them, these are my clients, I'm waiting to hear that she likes to be slapped during our romantic time together. And that's why she has that mark on her face that was included in the police report or the petition for domestic violence restraining order. And then once I'm done hearing the story, then I'm asking, okay, and which injury was from that? And almost always it's like, oh, it wasn't from that, but this is something that she likes. No, this is not something that you want to bring up. Number 5, don't focus too much on what the other party's motive is. So let's say that the other party kicked you out of the house, and it is a house that you own, and now you are stuck paying the mortgage on it, and they live there rent-free. They're not paying anything, and you have to pay for another place to live. Or let's say there are kids involved and there is a custody issue and they want sole custody, or they want child support, or they don't want to have to pay alimony. The judge already knows about those motives. So it's something that if, for example, you are in the house situation, you want the judge to know, but don't focus on it too much. But don't focus on it too much because the judge already knows about this, and the judge's job is not to change the law, but simply to interpret it and to apply the law to facts. So they have the law in front of them, and then they have the facts that you present. Number 6, don't talk about how normally you are a very calm and very patient person, but the other party would get you frustrated. And on that note, don't talk about other partners you've had and how everything was always good with them and you don't know why things went wrong with this one. There's always a first time that someone is abusive, and that is not going to be persuasive to the judge. So you want to make sure that you focus only on what is important. Don't bring up arguments that the judge is going to, in their mind, instantly shoot down, because the more of those arguments that they are shooting down in their mind, the less likely that they are ultimately going to side with you. Number 7, the other party drinking or using drugs. You can be an alcoholic, you can be drunk and still be the victim of abuse. You can be a drug user and still be the victim of abuse. In fact, people who are drinking or people who are using drugs could potentially be more vulnerable to abusive behavior. So unless you are using the fact that they are drinking or using drugs to challenge their memory, like how could they have possibly remembered the night in question when they admitted that they had 20 beers? Or to show that they fell down and hurt themselves, or somehow they injured themselves because they were so inebriated. I've actually had criminal cases where this is a big issue, when the other party does have substantial injuries, but it is, for example, because they got completely drunk and then fell down in their home, which was being renovated and which had a bunch of debris on the floor. So in that case, it is going to actually be very important. But it's not important to just discredit them or show off they're just a drunk or they're a drug user, because you still can't abuse a drunk or a drug user. I hope you found this video helpful, and look, you can keep binge watching YouTube hoping to find the answers or have them served up to you on a silver platter, which is what I do in the course, because whenever you're learning something new, what's I think the most challenging is that you don't know what you don't know. So you could be missing something big. Maybe you have certain things nailed because you did watch some of my YouTube videos or somebody else's YouTube videos. But what if you didn't watch a video on something that is really, really important, like the standard of proof or the objections that you can use to potentially keep the other side's evidence out? And so again, that is what I teach you in the course, from A to Z, everything that you need to know to win your hearing. I hope you found this video helpful, and if you did, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.